Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And if you have a question regarding your own foreclosure, guys, you can always send me an email to foreclosurehelp777@gmail.com, and I will try to help you answer that question. And you know, I am not an attorney, so I can't give legal advice, but I did fight my own foreclosure for 10 years. I have a lot of experience, so I could probably tell you what I would do if I was in your situation. But again, this channel is mostly for people fighting their own foreclosure pro se. So let's talk about today's topic, which are temporary restraining orders. Okay, so let's get into today's Bible verse of the day, which is Ecclesiastes 3:1. To everything there is a season and a time to every purpose under the heaven. And as you can see by this picture, a temporary restraining order was granted. God's timing is perfect. Keep the faith. Trust God. Know your rights. Fight for your home. I was in my home because I trusted our Lord Jesus Christ, and He helped me stay in mine. So over the years, I've seen homeowners focus entirely on filing a TRO. In some cases, however, a well-supported verified complaint asserting viable claims together with a properly filed lis pendens, where authorized by law, has provided a stronger litigation posture than just simply filing an emergency motion. The timing of a TRO is just as important as the legal arguments. What is a TRO? Let's talk about that first. What is a temporary restraining order? When is it appropriate? And what can it accomplish? What can it not accomplish? Many people think a TRO automatically stops foreclosure, and that's not how it works. A TRO is emergency relief. You're asking the court to preserve the status quo while the court considers the merits of your case. This is extraordinary relief, not routine relief. There is no magic TRO template. Every TRO depends upon your facts, your evidence, your claims, your state law, your court rules, and your timing. No two motions should look exactly alike. The judge will want evidence, not just allegations. Examples: recorded assignments, recorded documents, assignments, payment history, affidavits, correspondence, bankruptcy records, notices, court orders. Evidence matters. Timing is everything. This is where many homeowners make mistakes. Examples: filing 6 months before a sale. That's too far in advance. Filing after the sale. That won't work. Waiting until the night before without good explanation. Emergency motions require prompt action. I'd say 2 weeks before the sale is a good time. The 4 questions judges often consider. Courts generally look at questions such as: is there a substantial legal claim? Will the homeowner suffer irreparable harm without relief? How do the equities weigh? Is the requested relief consistent with public interest? The answer comes from evidence, not emotion. AI can help build a TRO. So instead of saying, write my TRO, say this instead. Say, ask me 20 questions you need answered before drafting a TRO. That one prompt alone will produce a much stronger first draft. Common mistakes: copying someone else's motion, using another state law, citing cases without verifying them, forgetting to read your local rules, filing without exhibits, waiting too long, assuming a template fits every case. Every case is different. Homeowner A might have a standing issue. Homeowner B might have a forged assignment. Homeowner C might have RESPA violations. Homeowner D might have bankruptcy stay issues. Homeowner E might have payment misapplication issues. The same motion, but different evidence and different arguments. This is why a template doesn't work. Temporary restraining order general format. This is just general information, guys, in case you want to do it yourself. You want the case caption created first, which has the name of the court, the parties, a place for the case number, the division, and the judge if assigned. The title: emergency motion for a temporary restraining order, or verified emergency motion for a temporary restorer, and a preliminary injunction, depending on the case and court. Then you want to have an introduction. Briefly explain what relief you are requesting, why the matter is an emergency, what event is about to occur like a sale or an eviction, and keep it short. Relevant facts. Explain what happened, when it happened, and who did what. What documents support those facts? This should be in chronological format. Legal standard. Explain the legal requirements the court applies when deciding whether or not to grant a TRO. Discuss Federal Rule 65 if you're in federal court, or your state's applicable rule or statute if in state court. And this section explains the legal test the judge must apply. Number 6, apply the facts to the law. This is where many homeowners struggle. Don't just quote legal standards, explain why your facts satisfy those standards. For example, why is the harm irreparable? Why are you likely to succeed? What evidence supports your position? Supporting evidence. Tell the court exactly what exhibits support the motion. Examples. Exhibit A would be a complaint. Exhibit B would be an assignment. Exhibit C would be a notice of sale. Exhibit D would be payment history. Exhibit E would be an affidavit, but always refer to the exhibits within the motion itself. Then you have requested relief. Tell the judge exactly what you want. For example, to stop the foreclosure sale, prevent recording of a deed, prevent eviction, preserve the status quo until the court rules, and be specific. Then conclusion, briefly summarize why emergency relief is warranted. Then comes your signature block, which includes a place for you to sign, your address, your phone number, and your email. Then you want to have a certificate of service, and then you want to look up your court rules, how to serve the other side. Here's an important point. This is only the basic structure of a TRO. It is not just a fill-in-the-blank template. Every section must be supported by specific facts, evidence, and law applicable to your own case. So before you file a TRO, ask yourself, what emergency am I trying to stop? When does it happen? What evidence proves the emergency? What law supports my request? Have I attached all necessary exhibits? Have I explained what money damages are not enough? Have I complied with my court's local rules? Have I served the opposing party or explained why notice should not be required if applicable? Most people think filing a TRO means they're done. In reality, they should be asking themselves, do I need a verified complaint? Do I need a lis pendens? Do I need affidavits or declarations? Do I need memorandum of law? Do I need proposed findings? Do I need to address the bond requirement? What happens if the TRO is denied? What happens if the defendant removes the case to federal court? Am I prepared to respond to a motion to dismiss? What happens after you file a TRO? Most homeowners think, well, I filed my TRO, the sale is automatically stopped, but not necessarily. In many non-judicial foreclosure states, simply filing a TRO does not automatically stop the foreclosure sale. Often the court must grant relief or another legal basis must exist before the sale is halted. That means filing the motion is only the first step. You may need a prompt hearing. You may need to satisfy notice requirements depending on the circumstances and your court's rules. You should understand your state's procedure well before the scheduled sale. So before filing, ask, does my court require a bond? Does my state law address an injunction bonds? If I'm in federal court, how does the court handle security under the applicable rules? Can I ask the court to reduce the bond? And can I ask the court to waive the bond if permitted by law? Many courts have discretion. In some jurisdictions, the amount of the bond, whether it's required at all, may depend upon the governing law and the specific circumstances of the case. That means don't assume. Always research your court rules and applicable case law. Be prepared for the other side's response. If your lawsuit includes federal claims or otherwise qualifies for federal jurisdiction, defendants may choose to remove the case to federal court. If that happens, they may file motions such as a motion to dismiss or a motion to strike, a motion for a more definite statement, an opposition to the TRO or preliminary injunction, or a motion to dissolve injunction relief if relief has been granted. Their objective is often to challenge your legal claims early in the case. So think of several moves ahead. Don't ask only, how do I file a TRO, but also ask, if the defendant removes the case, what is my plan? If they file a motion to dismiss, how will I respond? What evidence will I need at a hearing? If the TRO is denied, what are my next options? If the TRO is granted, what happens next? Litigation is a process, not a single filing. A chess match, not a single move. Filing a TRO is like making the opening move in a chess game. Your opponent is already thinking about their next move. You should be thinking about yours. The life cycle of a TRO is like this. The emergency develops. You file your complaint, you file your TRO motion, the court reviews the motion, the defendant responds, then there's a possible hearing, court grants or denies relief, the case continues, either it's a motion to dismiss, then you get discovery and summary judgment and trial. TRO intake checklist to give to your attorney if you are using one. Some people want to use an attorney, and their attorney will need a lot of information in order to craft a well-done TRO. So this is just for people that want to know this information ahead of time. You'll want to make sure your attorney gets your basic case information, the homeowner's full name, state, county, state or federal court, case number if you have one that exists, a judge if assigned, the plaintiff, the defendants, the servicer, the trustee if non-judicial, the current status of the case. Your attorney will want emergency information such as what emergency is happening, foreclosure sale date, sale time, eviction date if applicable. When did you first learn of it? Why is immediate relief needed? Copies of court documents. Please send to your attorney the complaint, the summons, the motion for summary judgment, notice of sale, notice of default, notice of acceleration, final judgment if applicable, and any prior court orders. Loan documents. You're going to want to send your attorney your note, your mortgage or deed of trust, any allonges, any assignments, loan modification agreements, payment history, payoff statement, default letters, servicing transfer notices. Now you want to tell your attorney, why do you believe the foreclosure is wrong? This is one of the most important questions. For example, the bank lacks standing, or there's a forged assignment, or payment errors, wrongful default amount, fraud, RESPA violations, bankruptcy issues, servicing errors, missing endorsements, statute limitations, other, explain. So you want to tell your attorney these things, why you believe the foreclosure is wrong. And then there's evidence. What documents support your position? So examples would be letters, emails, bank statements, checks, payment receipts, county records, prior court filings, affidavits, or bankruptcy documents. Prior litigation. Your attorney will want to know, have you ever filed bankruptcy or filed a previous lawsuit, appealed, requested mediation, filed a previous TRO, requested a loan modification. Deadlines, very important. Your attorney may miss an important deadline, which is the sale date, the hearing, the response deadline, eviction. Court rules, read these yourself, even if you have an attorney. It's always good to just make sure that they're doing it right too. What relief are you requesting exactly? Do you want the judge to order? Examples. You want to stop the sale, stop the eviction, prevent deed recording, preserve evidence, maintain status quo, or other. Now here's some AI questions that I would actually have AI ask additional questions. For example, based upon everything I uploaded, ask me 20 additional questions that an experienced foreclosure attorney would want answered before drafting a temporary restraining order. My favorite question, this is probably the most important one. What is the single strongest piece of evidence you have that supports your request for emergency relief? If you struggle to answer that, it's a signal that more investigation may be needed before drafting the motion. Now, what has the bank done wrong? Don't just say the bank is corrupt. Instead, tell me what document, what date, what evidence Which law? Which exhibit proves it? That's how judges think. A temporary restraining order is not just a document, it is a litigation strategy. A judge does not grant a temporary restraining order because you found a good template. A judge grants it because your facts, evidence, and the law justify emergency relief. Okay, guys, that does it for today's episode. I hope you enjoyed it and found it informative. If you have any questions or comments, you can leave them in the section below. And as always, everyone have a blessed day.